Hello everyone, and thank you for joining us for another edition of the Money Pros. I'm Oliver Tutt, certified financial planner practitioner, and I'll be your host for the next half hour as we talk about all the issues related to your money, how to make it, how to keep it, and hopefully how to help it grow. So let me give you a rundown on what we've got going for today's show. First up, we're going to be talking about 401k brokerage windows. Do you know what a brokerage window is? And should you be using it if it's available to you? So we're going to talk a little bit about that. We're also going to be joined by our estate planning pro, none other than Lynn Riley, attorney and partner at Cameron and Middleman. We're going to be talking about something called the Domestic Asset Protection Trust. And I got to tell you, this is something I didn't know a lot about until we started discussing this show topic. So she's going to elucidate us on exactly what it is and why you actually might need one. And we're going to be talking about the commission-based brokerage account. Are the days of the commission-based brokerage account numbered? This is a follow-up to a story we've been covering regularly here on the Money Pros with respect to a new Department of Labor fiduciary rule that relates to IRAs. It's having a major impact, though, in the industry, and I want to share with you some of the new developments as we've learned about them. And then finally, in our last segment, we've got some good news for the good guys when it comes to IRS scams. So I'll fill you in on what I mean with that a little bit later on in the show. So having said that, let's jump into our first topic, and that's going to be the 401k brokerage window. Now, first off, let's talk about what a brokerage window is. It actually allows participants in a 401k to go beyond the standard list of investments that they have. So if you have a 401k, if you've had one in the past, you're familiar generally there's going to be some kind of menu of funds that you have available. Some menus are longer than other. I've seen 401ks with 40 or more choices, and then there are other 401ks that might only have 5 or 6 or 7 choices. But a brokerage window allows you to go beyond the standard choices and essentially set up a separate sub-account that acts like a brokerage account. It allows you to buy virtually anything in most cases. You could buy stocks, you could buy bonds, you could buy other mutual funds, you could buy exchange-traded funds. In most cases, you can buy pretty much anything that would be offered inside of a standard brokerage account. So it significantly opens up the opportunities for investments inside of a 401k plan. So these brokerage windows are becoming more popular as 401k sponsors, and those are the employers that create these plans, actually seek to shrink the list of investments that are offered. There's a lot of research that indicates that the smaller the list of investments that's given to participants, the better job they'll do of actually selecting appropriate investments rather than being overwhelmed. The problem is they shrink the list. Some of the participants that are more sophisticated investors don't like that. And so the brokerage window is an opportunity to sort of please both parties that are involved here. So it narrows choices, making it easier to steer investors toward better portfolios. And interesting enough, plans that do offer these brokerage windows, and I'll point out that not every plan does, but plans that do, on average, have about 8% fewer investment options. So in fact, what we are seeing is that this is how plan sponsors are using it. They're cutting down on the normal menu of investments, which is probably going to be suitable for 90% of the participants in the plan. But for that 10% that want more, there's this brokerage window available so you can go and you can buy other investments. But there are a lot of things to consider here if you do have a brokerage window available to you as to whether or not you should use it. So let's throw up a slide and we're going to talk about a couple of these things. Things to consider. First is the investment choices. Now, some brokerage windows will pretty much allow you to invest in anything under the sun. Now, that gives you a lot of responsibility, but it also gives you a lot of opportunity. Other brokerage windows will have a much narrower selection of what's available to the participants. So consider whether the options that you want are actually available to you. Next thing is take a look at the difference in expenses. 401k expenses can vary. Sometimes they can be pretty expensive. Other times they can be very competitive. Most often the standard investment options are going to be your most competitively priced investments, although that's not always the case. In a brokerage window, expenses are all over the map because it's really up to you to choose what the appropriate investments are. And you're also going to have to worry about things like commissions, because in a brokerage window account, the plan sponsor may charge commissions for the purchase or sale of various investments that you would not typically have to deal with when you're dealing with your regular investment menu. Final thing to consider is excessive trading. I always worry about brokerage windows when clients open them up because unless they're very disciplined investors, you definitely run the risk of churning your own account. Now, it's not going to enrich any advisor in this case, but it could certainly do a lot of damage to your portfolio if you start chasing technology stocks or energy stocks or foreign currency related funds or something like that. You can be your own worst enemy a lot of times with investments, and unfortunately the brokerage window gives you a very handy weapon to beat yourself up with. So if you're going to use one, be very careful, but be aware that they're out there, and if you're interested in it, find out from your plan sponsor if the brokerage window is something that they offer. All right, up next, Lynn Riley, attorney and partner with Cameron & Middleman. We're going to be talking about domestic asset protection trust. Stay with us. We'll be right back. Welcome back to the Money Pros. With me now is our estate planning money pro, Lynn Riley with Cameron & Middleman. Lynn, thanks for being with us once again.
My pleasure.
Kind of an interesting topic here. And one of the reasons I think it's interesting is I always say in the open to the show, and you've seen it many, many times, we talk about helping people, and one of the things we want to help them with is helping them keep their money, right? Mm-hmm. And this is right along those lines. It's really all about keeping money. You know, for some people, that concern can be significant, right? For the wealthy or even the somewhat well off, depending on how you define those people. From a legal standpoint, what primarily are the threats to somebody's assets? We're not talking about the stock market crashing or a business going out of business or something like that, but what are the legal threats to somebody's money?
Sure, I think we're all worried about being sued, you know, and losing everything, say, to a judgment creditor after we've worked so hard to accumulate assets during our lifetime. Especially, you know, if there's a downturn in your business, you might worry about, you know, your obligations being satisfied from personal obligations. So creditors oftentimes is a significant concern. You might have a great successful practice or business and then have that one disgruntled customer and then everything's at risk.
So we're talking about creditors, and obviously that's going to apply, you know, to entrepreneurs and people like that. There are, imagine, also other situations that, you know, somebody said, well, I'm not an entrepreneur or whatever, but you could be involved in a car accident where the damages could exceed your insurance.
Rental properties, commercial properties that you own. Basically, you know, if you can think it, it can happen and you can be sued for it.
So there are a surprising number of threats. So what we want to talk about are the strategies to protect one's assets, and we're going to talk about one in particular. But let's talk about some things in general. One of the strategies for protecting assets is to potentially have your assets in what you referred to when we were talking about this as exempt assets. So what typically are what you would call exempt assets, and what does that mean exactly?
Sure. So many state and federal authorities have laws that protect certain assets. So for example, life insurance contracts often provide that the proceeds from life insurance are not subject to attachment by creditors. Retirement assets, individual retirement accounts, qualified retirement annuities, and qualified plans under the Internal Revenue Code offer protection from most creditors. Of course, not the family court that has an order for child support or alimony, or those assets are still subject to equitable division upon divorce, but from many creditors, retirement assets are protected. Many states have protect the equity in your home. So for instance, Rhode Island and Massachusetts protects up to $500,000 of equity in your home. But it really does vary from jurisdiction to jurisdiction. You can also have your primary residence owned as tenants by the entirety. So if you, for example, have a problem with your business or get into a car accident, but your spouse was not negligent, then they can't really break that tenants by the entirety with respect to that you know, primary residence. So owning those type of assets is helpful because they have that creditor protection for most creditors.
So obviously a valuable strategy, but some limitations. One, you know, depending on the nature of your, you know, your assets, you can't have everything in exempt assets. And then the exemptions vary from jurisdiction to jurisdiction. Absolutely. Or from what things will be protected depending on your situation. So another option for protecting assets is changing the ownership to having it owned by various different legal entities. So what are some of the entities? What are the options if I'm going to have my assets owned by someone else that will offer some protection?
Sure, you can often get creditor protection when you own an interest in an entity that owns the assets. So for instance, you have an interest in a corporation or a limited liability company or a limited partnership, or you have a beneficial interest in an asset protection trust. So for example, say you own a commercial property or a rental property, and you or your siblings own it and then transfer it into a limited partnership or a limited liability company. Your interest in that entity, if you have personal creditors or obligations, they can't directly attach those assets. They can only become an assignee of your interest in the entity. So if it's a family-controlled entity and you've got this existing creditor who's an assignee of your business interest, the family could say, okay, we're only going to be making limited distributions from the entity to you. Otherwise, we know it's just going to be lost to the creditor. So owning your, those assets in the entity and having your interest owned in that entity can offer you a good amount of creditor protection. Also asset protection trusts, but asset protection trusts are really only allowed in certain jurisdictions.
So we're going to be focusing in on the asset protection trust, but obviously this concept of having your assets owned by some other entity is really a critical thing. And then we talked about earlier the idea of exempt assets, but this isn't an all or nothing type of strategy. I mean, I would think that somebody that's interested in asset protection, they're going to be looking at more than one of these strategies?
Actually, you're absolutely right. The goal of asset protection is to put up as many barriers as you can in order to make it economically difficult for the creditor and costly for the creditor to attach those assets. So oftentimes you're using multiple strategies. So for example, if you have some of your properties, real and personal property, owned by a limited liability company or a limited partnership interest, part of your partnership interest or interest in that entity can be owned by the asset protection trust. Then you have double protection. Number one, you have protection because the only thing the creditor can attach if a distribution is made to you from the entity would really be the interest that's distributed to you. They can only get a charging owner. They can only be an assignee to what's actually distributed to you from the entity. Having those distributions then come to an asset protection trust, they can't actually attach that interest directly. If you had the LLC and they made distributions to you, once it's distributed to you, your creditor can attach it. If instead they distribute that interest, whether it's principal or certain property, to the asset protection trust, even though you're a beneficiary of the trust, the creditor can't attach it.
So that's what we want to focus on, is the domestic asset protection trust. Can you just what is it? I mean, what is a domestic? We talk about trusts on this show all the time with you, with other guests. I've talked about them, but they come in a lot of flavors, and this is a particular flavor. What is it?
So an asset protection trust is an irrevocable trust, okay? A domestic asset protection trust is established under special laws under a limited number of jurisdictions that allow them. You transfer a portion of your assets to the irrevocable trust, and you can remain a beneficiary of the trust, entitled to receive some income and principal by the trustee. And still, even though you're a beneficiary of the trust and even though you established the trust, those assets that are held by the trust are protected from your own creditors.
So how does it differ from maybe some of the more common trusts that we've talked about on this show, for example, a living trust?
Sure. A revocable living trust is a trust that you establish and fund during your lifetime, oftentimes so that those assets avoid probate upon your death. You can amend and revoke that trust at any time you want. You can take your assets in and out of that trust anytime you want. Because you can take those assets back at any time, invest title back into yourself, those assets aren't protected from your own creditors.
It's a pretty low commitment transaction, right?
Correct, correct. The asset protection trust is authorized in certain jurisdictions so that you can transfer your assets to the trust, still be a beneficiary of the trust, but it's irrevocable. You can't just revoke it as soon as you establish that trust.
So here's an important question. Do all states offer the ability to set up asset protection trusts?
No, and it's an important distinction. There's a limited number of jurisdictions. I think there's approximately 50 now that allow it. Rhode Island is one of them, and so is Alaska.
Amazingly enough, Rhode Island is one of them. Okay.
And actually, certain jurisdictions really say it's against public policy to have these self-settled asset protection trusts that allow you to take your assets, put it in a trust, still allow you to be a beneficiary of it, and prohibit or prevent or make it difficult for a creditor to attach it.
Which is a legitimate economic question, not what we're trying to deal with right now. But
Massachusetts is one of them. They say it's against public policy to have this type of trust, but Rhode Island thinks it's a good public policy to protect assets that you've built up during your lifetime from potential future creditors.
So Rhode Island actually allows you to do it. So let's talk about some requirements for the Rhode Island Domestic Asset Protection Trust. And I have a slide that you helped me prepare so we can walk through these things. So the first requirement that I have here is it's got to be irrevocable. We talked a little bit about this, but let's summarize that really quickly.
That's right. So it has to be irrevocable, meaning that once you establish it and you transfer some assets to the trust, you can't the following week then revoke it and take those assets back and put them back into yourself. So it has to be irrevocable.
Not a transaction you want to take lightly. You want to make sure this makes sense. Next thing we have up here is the Rhode Island laws govern. What do we mean by that?
Sure. So the Domestic Asset Protection Trust is allowed in only certain limited jurisdictions. Rhode Island has a statute on point called Qualified Disposition and Trust Act. That statute says if you establish a trust, you have to meet all these requirements. Number one, it's got to be governed by Rhode Island law. Okay. Number two, you got to have a Rhode Island trustee, and it can't be yourself. Okay. So you have to have a Rhode Island trustee, which can be a person that lives in Rhode Island, or if it's not an individual, it can be a bank or trust company that is allowed to do business. It's qualified to do business in the state of Rhode Island. At least a portion of the assets has to be located here, say deposited with a financial institution, or the personal or real property located here. And then the trustee has to maintain at least some of the records here and must administer some of the trust. There must be material participation in the Rhode Island trustee's administration of the trust. For example, making sure that tax returns are prepared.
All right, so we only have about 30 seconds left. There's two more items I want to get to on the slide. One is the spendthrift clause, and
Yes.
I'm not sure if we can throw up the second one as well. We can. Fraudulent transfers. Let's just talk about those two things with the half a minute we have left.
Sure. So with respect to the irrevocable trust must include a provision that prohibits a beneficiary from assigning or transferring or pledging their beneficial interest in the trust. That's a spendthrift clause. That language has to be in the trust for it to qualify as an asset protection trust. And the asset protection trust does offer a great deal of protection, and it makes it very difficult for a creditor to attach assets. But if you establish and transfer assets to the asset protection trust, when you already have an existing creditor and your purpose is really to delay and hinder that particular creditor that's already in existence, then that could be deemed a fraudulent transfer and it can be unwound.
So this is really a before the problem arises strategy, but clearly a very valuable strategy among many if a viewer's concern is keeping their assets safe from other people that may seek to grab them, right?
Right, and even if you have existing creditors but suit hasn't been filed yet, it is still wise to establish the asset protection trust because it also provides for statute of limitations. The creditor has to do something sooner rather than later.
Fascinating topic, Lynn.
Yeah.
Thank you very much.
You're welcome.
All right, stay with us. Up next, we're going to be talking about whether we're looking at the death of the commission-based brokerage account. Stay tuned. We'll talk about it. More to come. Welcome back to the Money Pros. So for a very, very long time, as long as there have been brokerage accounts, the most common way that a financial advisor has been compensated has been for essentially selling investments. You make a recommendation to buy a stock or a mutual fund or something like that, or to sell one, and that transaction potentially generates a commission to the financial advisor. So that's been the case and it remains the case in many, many scenarios as you work with a financial advisor. Over the past 20 or so years, it's been more and more common to work with financial advisors on a fee arrangement. Some advisors will work under both arrangements, and others will only do one or the other, with some being fee only. Now, without getting into the rudiments of which one is better, and we've talked about that on the show before, there is some evidence that the idea of the commission-based brokerage account is becoming under pressure, and that's specifically related to some new regulations that came out from the Department of Labor. Now, the Department of Labor is responsible for regulating a lot of things, but they have purview over retirement plans, and retirement plans include IRA accounts, which is a massive portion of the brokerage account industry. And they've created a new rule that is commonly referred to as the fiduciary rule. And we've talked about this on the show before. What it means is that if you are an advisor to somebody that owns an IRA, you are considered a fiduciary. Now that puts you at a higher level of responsibility than a typical financial advisor working under a commission-based arrangement. Now this regulation does not ban the use of commission-based accounts in IRAs. However, many brokerage firms are determining on their own that there are too many risks to offering commission-based brokerage accounts inside of individual retirement accounts. For example, Bank of America Merrill Lynch announced that they will no longer offer commission-based accounts inside of IRAs. Another large brokerage firm, Edward Jones, announced that they'll keep commission-based IRAs, but now allow but not allow the purchase of mutual funds or exchange-traded funds in those accounts. So this fiduciary rule just came into effect. Financial advisors are just now figuring out exactly how to deal with it, and already we're seeing major brokerage firms announcing that they will no longer offer commission-based accounts in IRAs. So the question arises, with the pressure of commission-based accounts in IRA accounts related to this fiduciary rule from the Department of Labor, will commission-based accounts start to go the way of the dodo bird in other types of accounts, like individual joint accounts, non-retirement-based accounts? This is a massive shift inside of the industry, and I'll be the first one to tell you, as somebody that works almost exclusively on a fee basis, that working on a fee basis is not always the right way to do it, particularly for those people that have smaller assets or do very few transactions. Commission-based accounts can be the best way to go, but you have to be a very knowledgeable consumer in that situation. So this is really a sea change in the financial advice business. We're going to continue to talk about it here on the Money Pros, but that's the last thing or the latest thing that we've learned about. All right, stay tuned. We're going to have some news, one for the good guys, coming up here on the Money Pros. Welcome back to the Money Pros. Okay, in our last segment, I want to share with you some good news. Now, we've talked about this on the show before, and we've probably all gotten these phone calls. IRS, or people claiming to be from the IRS, calling to tell you that you owe lots and lots of money, and if you don't pay it immediately, you're going to be thrown in prison. So we call these IRS scammers, and there's recently some good news related to this. Now, the Treasury Inspector General for the IRS has received 1.7 million complaints regarding IRS impersonation phone calls, and according to the latest information, 8,800 victims report paying out over $47 million to these scammers. So this is a scam that's working pretty well. So earlier this month, police in India raided a call center in Mumbai, and they arrested 70 people running 9 different call centers that employed over 700 different telemarketers. Their only job was to call Americans and threaten jail time if they didn't pay up on these fictitious IRS debts. So I want all Money Pros viewers to remember that the IRS will never initiate contact with you over the phone or over an email. They certainly won't start threatening to send the police to your house or to send you to jail. Generally, you will get a written communication from them first, and there's no mistaking these written communications when you get them. So I thought I'd pass along a little good news. It doesn't pay to scam, particularly when it comes to the IRS. Thanks for watching. We'll see you again next time right here on the Money Pros.